Good morning.
Good morning.
Right.
Right. Good morning, everybody. My name is Judge Mary Nardella. I want to welcome you to an oral argument session of the 6th District Court of Appeal. With me on our panel today are Judge Brownlee, and we want to thank the Chief Justice of the Florida Supreme Court for allowing Judge Lambert, who is serving temporarily on our court, to join us today and to be on this panel, and to thank Judge Lambert for his public service. Today, we're going to have an oral argument on Liberty Mutual versus Robert A. Lee et al. It's number 232377. I want to remind everyone that our argument today will be live streamed on YouTube. Counsel for appellant and counsel for appellee, you both get 20 minutes per side, but counsel for appellant can reserve time for rebuttal if he so chooses. Counsel, is there a amount of time you would like to reserve?
8 minutes, Your Honor, please.
Mr. Stevens, there's a clock. You should be able to see it to help you keep track as well, but we will reserve 8 minutes for rebuttal, and I'll try and remind you, but like I said, it may be imperfect, so please watch the clock as well. And Mr. Stevens, whenever you're ready, please proceed.
Thank you, Your Honors. May it please the court. Michael Stevens on behalf of the appellant Liberty Mutual Insurance Company. Just a quick thank you on behalf of my wife and 2 young children for allowing me to appear virtually for these hearings so I can be home for dinner tonight. The sole issue before this court right now is whether the lower court erred by using the settlement date between the appellee and the third-party tortfeasor, and not the date it actually ruled on the motion for equitable distribution for purposes of calculating Liberty Mutual's reimbursement of its lien under Florida Statute 44039 3A. I would submit to this court.
Counsel, so that's about a 2-year difference between settlement date and determinative date by the trial court?
Yes, Your Honor, that is correct.
Okay. What is there something in the record that tells us how old Mr. Lee is?
Oh, that's a great question. And his age was not part of my portion of the case since I was only representing the carrier aspect of it, but I don't have that answer for you on his age.
Okay, well, let me ask this. Is there,
Yes.
it sounds like Mr. Lee was significantly injured. The work comp benefits that I guess your client is paying, they're continuing to pay, right?
Yes, Your Honor.
Bi-weekly or whatever term frame?
I believe even now. I believe even now.
Is there some, under the work comp statute, is there some termination dates of when these benefits are no longer payable?
Well, Your Honor, I believe that they continue indefinitely until there's no need anymore for either a medical or indemnity benefit that can be paid, or alternatively, the injured worker can actually settle their workers' comp claim with the carrier if they wanted to, but neither of those has happened, at least as far as the record is concerned in this case.
So getting to where I'm trying to get to, you don't need to be clairvoyant because I'm not sure I was clear when I was asking questions. So theoretically, if Mr. Lee needs care and treatment for the rest of his life related to this work injury and is got doctors documenting that, then you got your Liberty Mutual will be paying to get biweekly benefits still until he passes, right?
That's typically how these policies work. The whole purpose is if somebody does apply for workers' compensation benefits and they qualify for them, then they are paid during that period of time. Yes.
Okay, and then once, and I'm not wishing ill health on Mr. Lee, obviously, but upon his passing, then your obligation to pay seems like that would end, I assume.
I believe that is correct. I don't want to get too far over my skis over here on what I'm prepared to confirm right now, because that wasn't really part of what I briefed for today.
I mean, I don't, whether there's death benefits or not, I don't know, but I mean,
Right.
at some point, it makes logical, it's a logical conclusion, which doesn't always translate to statutory interpretation, but it's a logical conclusion that when the gentleman passes related to this accident, he no longer gets benefits to pay him for that. And if there's some statutory death benefit, that is a finite event.
I would agree with that logic, Your Honor.
Okay. And then I guess then my question, if I'm understanding the appellee's position, there's this 2-year period where your side says that should be benefits paid, that should be part of the lump sum number, an additional approximate $33,000. they're saying, no, you can recover it as you are now recovering. You're not paying the full amount of your work comp benefits. You're paying whatever the number you would be paying minus the 11.61%, correct?
Well,
That's what you're doing right now. Let's just follow with me. That's what you're doing right now.
I'm attempting to confirm that a lien existed on all amounts that were paid by Liberty Mutual to Mr. Lee up until the point of the court's order on the motion for equitable distribution. The appellee is actually not saying that we're going to get that 11.61% of what we've paid in this period of time someplace else. In fact, the argument in their motion, in their answer, is that this is a consequence of the decision that Liberty Mutual made to actually contest the delta between what they believe the fair value was or the full value of the case and what we believed the full value of the case. And that was the purpose of the equitable distribution hearing.
So appellee's position is whatever was paid between settlement date and determination date, the approximate $33,000 that you would otherwise be entitled to, that's not recoverable by, is that the appellee's position as you understand it?
Almost like a penalty, Your Honor. Like almost like
a call it. That's what
right.
You understand to happen.
Yes. Yes, I believe that was their position below, and their position now before this court is that the $300,000 in benefits paid between settlement date and the date the court gave us that 11.61%, it's out the window, that the carrier didn't have a.
That's not their position. If they say, look, you can still recoup that, just take it out of the monthly or biweekly payments under the 11.61%. It seems like once the client passes, is there a statutory provision that says, okay, we don't have to pay him, but he still owes us this 33 grand. So we want to somehow keep getting money. That's why I'm trying to wrap my head around how you guys, assuming you're entitled to it, how you ever recover it under the statute or under the appellee's position.
Well, I don't understand how we would recover it either under the appellee's position,
That's
but
what
I will.
You're unhappy about, and that's what you want us to fix.
Well, yes, and I would ask.
Yeah, I mean, I think I'm getting questions that help you. You can say, yeah, that's
yes,
good
yes,
point, Lambert.
Yes, Judge. Point well proposed, but it all goes back to the statute that essentially gave us the right in the first place, which is 44039. All right. Only reason why that statute even kicks in is if somebody voluntarily elects to receive workers' compensation benefits. And the whole purpose of the statute, if you read all the sections, is to protect and kind of codify the equitable resolution of how a carrier gets paid back in some form if a recovery is made with respect to their third-party claim. And there's really no ambiguity in that statute that the carrier has a lien on what it has paid and what is to be paid. And that's the big ticket item here, is that there really is no ambiguity in that sense. Section 2 of 44039 starts off with confirming that my client is subrogated to the rights to the extent that they paid or to be paid. Section 3A talks about the fact that we have a lien in place on anything it has paid or what is to be paid. In fact, in 3A, which is this section that deals with a lien, the paid or to be paid language is referenced 3 times. In the statute as a whole, it touches on that same language 7 times. Every penny that a carrier pays out for an injured worker on a workers' compensation benefit has been accounted for by the members of the legislature that drafted this statute. For every penny that is paid out for the benefit to the injured employee, the legislature crafted methodologies where the carrier receives either a lump sum payment for what it has paid out or a future credit for what is to be paid out. And what's
Mr. Stevens,
yes,
is it undisputed in this case? And this might seem like a silly question, but is it undisputed that in the final judgment, the trial judge did not make up for this sort of gap between the settlement date and the date of the equitable distribution? Is that everyone's understanding that there is this gap in this case? Because when I look at paragraph 2, it does state, once it talks about the amount that has been paid, right, and your client is going to be reimbursed for that, which shall be paid to Liberty Mutual's counsel within 10 days. It then says Liberty Mutual shall also be entitled to a future credit in the amount of 11.61 for any future benefits paid. So I guess that is a gap in the statute. And otherwise, I think what Judge Lambert is saying, right, is there would have been some mechanism by which y'all could recover that money that exists in that gap.
So as the statute reads, there is zero mechanism as prescribed by the legislature on how we would ever recover our 11.61% of those $300,000 that were paid in benefits from the date of the settlement to the date of the equitable distribution hearing.
Okay.
And
All right. So, and everyone agrees there's a gap.
I
I'll
believe
ask that.
I believe that was conceded in their brief and below it, and simply the argument with that was that yes, there's a gap, but it's they shot themselves in the foot by not agreeing to our number on day one and exercising the rights under the statute to have an equitable distribution hearing.
Right. I mean, there's no statutory provision that's applying to the facts of this case that says, okay, the number turns out to be 11.61% credit against future payments. And oh, by the way, because you've already paid some in the interim, you can take another 10% against your payment until you recoup your 33 grand. There's nothing remotely saying that in the statute.
Well, it's the paid or to be paid language, Your Honor. And if we want to talk, this is not a section of this.
You could have just said, no, hey, you're right, Lamb. There's nothing in the statute that says that. And that's what the problem is. And that's why we should get it at the time of determination, because we have paid it. Paid or to be paid.
Paid or to be paid. Like I said, 7 times.
Pay up until the date of determination by the trial judge about the equitable distribution of the percentage of the lien that was paid. Therefore, that is a finite number, and we should get that number. I mean, I think there's some whiff of the problem is he doesn't have the money anymore, but that's neither here. Well, I don't know whether he does or not. That's neither here. That's between you how to collect things, or your company your client how to collect this judgment or not.
So Your Honor, these funds are held in trust. This dispute has been continuing on. That's all that this is about how much of this pizza pie do we get to slice off according to the Florida statute 44039. This isn't about
you get the piece of pie now. If your side wins in this appeal, for lack of a better term, you get the $33,000 pizza pie.
We get the piece of the pie that the legislature says that we're entitled to. No more, no less. No more, no less.
I know. Nobody's suggesting you're gaming the system.
Right.
I guess my point is it exists. So if Mr. Shepard wants your side to lose this appeal, you want your side to win. If you win, then you can get your $33,000 check, for lack of a better term.
Yes, Your Honor. And just look.
That's all I wanted to know.
Okay.
Go ahead.
So kind of stepping back again, the difference between the lump sum and the future credit, again, the net benefit to the appellee is the same because the percentage is the same. But what's really important here, and what was argued below and what's being argued now, is whether the statute has language that identifies the point in time of where liberties lien should be cut off and reduced to a future credit. And I've talked about this already, how many times it says the expense paid or to be paid. The reality is that Liberty Mutual never had an opportunity to fully resolve this issue and know their number until the court actually ruled on that day in March of 2023 on their motion for equitable distribution. They didn't know what the percentage was going to be until that ruling came in. Just think about like the precarious position they were in at that point. Liberty Mutual is actively paying significant compensation benefits to Mr. Lee because of his injury. He settles his case in February of 2021, and a dispute arises as to what percentage Liberty Mutual should be reimbursed from the settlement proceeds. In this moment in time, Liberty Mutual absolutely cannot just reduce the benefit payments on behalf of Mr. Lee. I know I'm going over my time a little bit right now that I want to reserve, but
Nor could you stop making payments until it's determined.
That's exactly right. So not only did we not know what the number was, imagine in a situation where we think it's 30%. So you know what, right now, let's go ahead and drop how much we're paying him by 30%. And then one day when the court makes time to hear our motion for equitable distribution hearing, we'll balance the books then. Maybe we overpaid him, maybe we underpaid him. We couldn't do that. That could never happen. We had to pay him 100% of his benefits until either an agreement was made between all of us, which clearly we didn't get to, or the day that the court actually put in writing a determination of the percentage we were entitled to. And that was that day on March 15th, 2023. That was the first time we had a formal order to actually decide what our percentage was. It wasn't the arbitrator who decided that. If you take a look at the order on arbitration, the arbitrator made one finding. What was the full value of this case? And that number gets plugged into the formula that's part of 44039-3A. So without that, we were completely inhibited from this. But the big picture on this whole thing, and Manfredo is really the only case that kind of talks about this lien. And to Appellee's point, they didn't dig in to the timing of the payments. But what you do see in that case is you see a trial court after an equitable distribution hearing apply a percentage to the amount that had been paid. When the third DCA took it up, Judge Levy did the same thing. They changed the percentage because they said that the trial court got it wrong and applied a little too much comparative fault to it and brought the number to what it should be, but also said to be paid. When they certified it to the Supreme Court did the exact same thing. They agreed with the third DCA. They said, you're right, the number was wrong, but we're going to apply it to what was to be paid. And the reason, Your Honors, why they did that was because the statute does not allow for a gap. There's no free money, no windfalls that should apply to an employee, an injured worker, simply because there's a dispute. So,
Mr.
beyond all,
Stevens,
yes, Your Honor.
would your client be here today? I mean, I understand the math and everything and why you're saying that it's the same number, right? But would you be here today if the trial judge had made the initial determination about the 74 approximately grand and then later said, and we will so the cutoff date will be settlement and we'll treat the future, or not, they wouldn't be future then, we'll treat the payments that were made after the date of the settlement as where you just take that pro rata share of the 11.61% and you go about your day. Would y'all be quibbling with that? You would think under Manfredo and this equitable distribution date, that's not exactly right, but maybe it's neither here nor there if the numbers are the same, or am I missing something on that front?
You're not missing it. The reason why we're here is because there's no mechanism to fix what happened with the lower court. There's no forward-looking opportunity for them to recover the 11.61% that they paid on the $300,000. So look, if the court, you're guessing what my client would have done in that moment, like if the court had fashioned a remedy that allowed for that 11.61% of that $300,000 to have a way to actually get back to Liberty Mutual, I would like to think that we would have probably found a way, but the truth of the matter is we were told that $300,000 is gone. You paid it, say goodbye. You get your 11.61% from this day forward. And that's not what the statute said. It just doesn't say that. And the statute is designed to protect the carrier's rights of reimbursement in a fair and equitable way. And like I said before, Liberty Mutual is not asking for anything more or less than what was equitably prescribed in that statute. So look, with that, I'm going to reserve the remainder of my time, but I would ask this court reverse the trial court's ruling with directions to recalculate Liberty Mutual's lien consistent with the statute to incorporate all benefits paid up to that date on March 15th, 2023. Thank you.
Mr. Shepard, whenever you're ready.
May it please the court, Tom Shepard on behalf of the appellee, Robert A. Lee. This case presents this court with a very narrow question. Pursuant to section 440.39 in Manfredo, what is the date on which the insurer's lien is valued for purposes of determining?
Counsel, I think everyone, including at the hearing below, everyone is focusing on this date, right? Whether the statute's ambiguous or unambiguous and what exactly that date is in the statute. You agree there is no date do you agree with that there is no date in the statute?
I wouldn't, Your Honor. I would say that the context of the statute makes it clear that the judgment or settlement date is the date to be used. And we see that
it comes out of the judgment or settlement, right? Let me pull the statutory language. I guess I'm saying this because everybody seems to be focused on the date, but isn't that truly just to determine at what point in time what has been paid and then what will be paid in the future, just to sort of figure out how much Liberty Mutual has already come out of pocket?
Yes, Your Honor.
Is that really what the statute is contemplating that we focus on?
I would agree that the date that we are focused on is the delineation between what the carrier has paid and future benefits to be paid for purposes of determining the Manfredo formula. Is
there anywhere in this statute that, I mean, say hypothetically we adopt your view of this and we say, no doubt it's the date of the settlement, whatever gap, they're just on the hook for whatever they paid in the gap. Number one, I think that insurance companies, I don't know, right? But why would they pay into that gap anymore? But setting that aside, is there something in the statute that says, like, something that we could construe to mean they're not actually entitled to everything that they pay? Because paid or to be paid, forget about that language. There's sort of an unless in there. Aren't you asking us to read in an unless they have paid between these two critical dates?
No, Your Honor, and we don't disagree that they're entitled to these funds. We just disagree that they're entitled to have the date of determination be the date of equitable distribution, because that simply isn't in the statute.
Wait, tell me about that. You're not disputing that they're entitled to that extra 33 grand?
No, Your Honor, if this case was affirmed, we would write them a check for the 33 grand. That's being held.
Well, if we affirm it, you would, but so I guess that's going back to my my question originally to opposing counsel is it undisputed that the trial court, it seems to be undisputed that the trial court's order creates this gap. Do you agree with that?
I would agree that there is a period of time that I'm sorry, I guess I don't understand.
Sorry, so the gap would be that that Liberty Mutual, pursuant to the final judgment, is not entitled to any reimbursement for monies paid as of the date of settlement to the date of equitable distribution. Is that how you read the final judgment as well?
I wouldn't read it that way. I don't think that there's no way for Liberty to recover. I think that Liberty.
What's the mechanism then? How do they recover that? Because from the equitable distribution date going forward, your client is receiving biweekly benefits or what have you, and then they subtract 11.61% for benefits going forward. Okay, they've already paid they paid the $33,000 that they would be, it seems like you just said they're entitled to it. They didn't have the option in this 2-year period to not pay your client the benefits pending equitable distribution determination. So they did what they did with the understanding that there's going to be some percentage that they're entitled to recapture, for lack of a better term.
Yes, Your Honor. And
agree with all that. So at some point, as Judge Brownlee's saying, there's nothing that's clear in that final judgment that says, okay, well, what do we do with this gap period? And you seem to be saying that if we affirm, you'll write that Mr. Stevens' client a check. Well, then why don't you? We just call it a day.
Yes,
Your Honor.
Go ahead.
I'm sorry, Judge Brownlee.
No, please, will you answer that for me? I'm confused. Should we have sent you to mediation instead?
No, I mean, we think there are 3 ways that the carrier can recover the funds here. The first being they can request the funds from claimant's counsel, which again, I said that we'd be prepared to say that. And these funds are held in trust and they can't be dispersed until there's an agreement about the satisfaction of what Liberty is owed. The second would be if the parties can't come to an agreement on that, Liberty would have a cause of action for unjust enrichment. And the third would be that Liberty could have a cause of action against the tortfeasor.
Well, I guess I'm a little, I apologize, let me jump. I'm still a little confused then. If it's a finite number, I mean, they paid X dollars between your client's settlement with the tortfeasor and the date of the equitable distribution. And then there's an 11.61% determination by the judge, which nobody is quibbling with here. So it seems then you would take whatever I'll use 300,000 as a round number. You take the 300,000 that Mr. Stevens' client, is paid in the 2-year gap. You then multiply that by 11.61. That gives you a number. I'll use the round number 33,000. And I guess I'm a little puzzled here. Why then you guys just didn't get on the phone with each other and say, okay, you're entitled to it, Stevens, Liberty Mutual. Here's the number. How do you want the money? You want me to give you in $10 bills or write you a check or something, and we'll call it a day? Are you guys just asking us to make some ruling that says it's either the settlement day or the equitable distribution day under the statute? For us to interpret the statute, even though that would seem unnecessary at this point?
Right. The problem with Liberty's proposed rule is when you look at it in practice. So for Manfredo, we need 4 variables to calculate the carrier share of the settlement: the amount of the settlement or judgment, the full value of the claim, the attorney's fees and costs of the claimant, and then the amount that the carrier has paid. And the fourth variable is what we're really talking about here. And
Which is what, the amount they've paid?
the amount that the carrier has paid, quote unquote, for, and the question is, do we calculate the amount the carrier has paid as of the date or settlement or judgment, or the date of equitable distribution? And the problem with calculating it from the date of equitable distribution is that in the vast majority of cases, there is no order on equitable distribution. The cases settle outside of court. And so then you don't have this fourth variable to insert. And
But isn't that why the statute reads judgment or settlement?
I'm sorry?
Isn't that contemplated by the statute itself, which reads the date of judgment or settlement? If you don't ever get an equitable distribution judgment?
I believe that the judgment or settlement that is discussing is the cutoff of the claimant's suit against the tortfeasor, not any dispute between the workers' compensation carrier and the claimant. You see that in the where the statute discusses the attorney's fees and costs of the claimant in prosecution of its suit against the tortfeasor. So the cutoff is the judgment or settlement for at least 3 out of 4 of these variables, the first, the second, and the third. But Liberty proposes the fourth just continues to grow. And you would say that doesn't make any sense either. So you would have this problem where first, in the most cases, you wouldn't be able to calculate that fourth variable because there's no order on equitable distribution. And, the term distribution doesn't appear anywhere in 3A. So, Liberty says that it's clear and unambiguous that that's the date to be used, but there's no mention.
Counsel, given this fourth variable that you're talking about, I'm struggling to see, even if we do read it your way, I don't understand how we can allow for a gap when it looks, at least from the plain language of the statute, like that statute is telling the court to reimburse when using the Manfredo formula, right? That's fine. We're going to use this formula to pay them back, but they get paid back and they get a percentage of what they've paid and what's paid in the future. And there's nowhere, regardless of what the fourth variable is, there is nowhere that, or at least I'm asking you, I suppose, to tell us where in the statute it would allow them to not get paid back for a certain sum of money. And I guess where I'm going with it, we might not need to get there. I'm kind of struggling with the point that Judge Lambert just left off on, which is perhaps it's your position that Mr. Stevens is wrong when he argues that the math is the same, that they're still going to be entitled to 11.61%. Okay. And then the number is going to be the same either way. So if we take paid or if we take future payments, it doesn't seem to me that you have a dispute with the number. Do you have a dispute with the number? And
No,
if
Your Honor.
not, I can't figure out, then I can't figure out why we're here.
I mean, we didn't file the appeal. And
Well, that's fair. You're the appellee.
Yeah,
Well, I think
yes,
that he
Your Honor.
doesn't know. Perhaps Mr. Stevens doesn't know that you're okay with the number. Would being okay with the number just, I mean, you've won below, right? So if the trial, you have a order granting a motion for final judgment in your hand that says you have the date that you want. So if y'all presumably agreed on the number, you think the suit goes away?
Yes, Your Honor. I don't see any reason why it wouldn't.
But you all do agree on the number, so maybe I'm guessing wrong, but I think Mr. Stevens is probably the first time he heard until today that you'd actually all write him a check for the 33,000 he wants for the gap, the roughly 33,000 for the gap period. Now you're as an ethical lawyer, you're telling us that you'll do that, but I mean, if we walk this through and just say, well, they've all figured it out, we'll just PCA and call it a day. Why write anything to muddy up the waters? We'll wait till some other case that's more at odds with each other. Then, I'm not saying you should then go back on what you're telling us as a panel here, obviously, but I mean, the problem is to say, Well, it seems like we would reverse to say, okay, here's the time period. It says, looking at the plain language of the statute, benefits paid. They paid the 300,000 in the 2-year period. It is a readily calculable amount to which they're entitled to be reimbursed. And therefore that's what the judge, that's what the judge's order should clarify. And then from that point forward, then they're just paying your client the weekly or biweekly benefits minus 11.61% until I guess your client continues for treatment related to this accident or passes away. I guess I should ask you, I'll ask, your client in theory could get this money till the day he dies if he's still getting treated for the work related the benefits, right?
I must confess, Your Honor, that's my understanding, but as Mr. Stevens said, that wasn't what was briefed, so I can't give you a 100% answer on that,
Right.
but that is my understanding.
Well, the context of me asking that is at some point, if your position was they're entitled to the 33 grand, but they just take it out of credits, future credits. If there's always going to be payments till the day you die, there's no ability to recoup this finite 33,000, correct?
I wouldn't disagree with that. I would say that.
Okay, so you agree with that?
I would agree with that.
All right,
There would be
disagree. Double
three
negative is
ways.
a positive.
I'm sorry.
Go ahead. No, that's all right. I just want to make sure I'm clear with what you're saying.
Correct. I would say that there are 3 ways. I went over the 3 ways that we believe Liberty could recover in this case. Obviously, we're prepared to write them a check and don't disagree that they're entitled to the funds. I think the sole argument and the limited issue that's before the court is what date is being used for the valuation of the lien with respect to the carrier's share of the settlement proceeds. And we do believe that date has to be the date of the judgment or the settlement pursuant to the statute. There's nowhere in section 3A where it talks about this order on equitable distribution.
Well, it can't be the date of the settlement. Then they wouldn't be entitled to this 33 grand lump sum, this 33 grand over the next 2 years, because you settled it 2 years earlier. So that's a finite number. They have, under the applying retroactively 11.61%, they would get a $74,000 lump sum, which maybe I shouldn't assume they got, but they got. So, but they continued paying post-settlement as they were required to statutorily. And then now the 11.6, now they're entitled to, your client's not entitled to the full amount of those 2-year payments, right?
Yes, Your Honor.
Seems
but
to be what you're saying, because you're telling him you'll pay him $33,000, which reflects the 11.61% overpayment of what your client has received in the 2-year gap, right?
Yes, Your Honor, and I will admit that this question is a bit academic, considering that we don't disagree that they're entitled to the funds. But the way I'd put it is, the statute gives both a lump sum payment out of the settlement or judgment, as well as a future credit. And so the question is that gap a future credit, or is it part of that lump sum settlement that
But if it's a future credit, then they would only be able to take the monies percentage-wise out of the bi-weekly payments, right?
Well, no, Your Honor, we argued that they would be entitled to get that fund out of from the claimant's trial counsel or via a cause of action for.
Well, you're saying that professionally and ethically, but a literal reading of the order wouldn't necessarily suggest that, would it?
I don't think the order speaks necessarily to the gap that's there.
Yeah, so the gap, so there's nothing that says to Mr. Stevens' client that you're getting your gap money, other than his opposing counsel saying, hey, don't worry about it. When that 6 DCA is done with this, we're going to write you a check.
Yeah,
No matter which way it goes.
Right, I would say, Your Honor, that the judgment does not speak to it at all, either way.
And that's why he's here. Mr. Stevens saying it doesn't speak to it, so we want to make sure we have some clarity about where this is coming from. And he's probably smiling right now saying, well, we got some clarity. We're going to get our money one way or another, because that nice fellow, Mr. Shepard, says we're going to write him a check. So you should have told me that 3 months ago before I had to write a brief or something. I don't know.
Your Honor,
I don't know. It is what we're here, so we'll plow forward.
yes. So I just kind of in sum, I would say that the text of the statute certainly doesn't say that an order on equitable distribution must be used as the date. They're
But we
practical.
have a judgment, this would presumably be, we've got the order on Robert A. Lee's motion for final judgment, right? That's what I have here. So if presumably a final judgment comes out after or contemporaneous with an order on the equitable distribution, noting finality in the case, why isn't that what the statute's talking about?
I'm sorry, Aaron, why isn't the order on equitable distribution the judgment or settlement that the statute's talking about?
Yeah, I mean, doesn't the
Question?
term judgment mean we could go way past this settlement? And then now we've looked at equitable distribution motions from other parties. We've handled some things. Now the judgment comes out. That would presume, I could imagine a scenario where that's 2 years after the mediation and the settlement.
I mean, Your Honor, we would certainly not have a problem but I think Liberty might have a problem with our attorney's fees and costs running all the way up to the judgment on the order on equitable distribution. I think that's one of the issues. When you read the statute in context, the judgment or the settlement or judgment that it's discussing is clearly talking about the claimant's suit against the tortfeasor. And I think that the equitable distribution proceedings aren't discussed in 3A. Maybe discussed elsewhere in statute, but they're not in 3A. Let's see. But I think it's also useful to look at this through the lens of subrogation, right? So Luscombe says we look at the carrier's rights in this context through subrogation. And if Mr. Lee's rights are cut off vis-a-vis the tortfeasor at the judgment or settlement date, then Liberty's rights with respect to increasing its lien for the purposes of the judgment or settlement share should be cut off on that date as well. Otherwise, Liberty is going to be entitled to greater rights than my client, which is a violation of the black letter subrogation law. For the reasons that we discussed today and those in our brief, we would ask that this court affirm. Thank you.
May I respond, Your Honors?
Yes, counsel, you have 3 minutes and 38 seconds whenever you're ready.
Calling what we've just done over the last year academic would be, I'd say it's a little frustrating. We're here today because they did not and have not agreed to pay for their percentage during that gap. That's why my client.
This is the first you've heard about it.
You read my face, Your Honor. Okay. The fact that a comment was made in his response that if you go ahead and affirm this, they're stroking my client a check, I almost fell over. I don't understand why suddenly at oral arguments after we've spent all this time and energy to clarify a point, suddenly they're ready to write a check. If they were so ready to write a check, why didn't they do that already? What's stopping them from having done it before today? I wasn't stopping them from doing it. The reason why my client decided to take an appeal on this issue, and also why I would respectfully submit that a PCA doesn't solve this problem long term, is because a trial court order exists right now that the plaintiff's bar will share that shows a judge in Florida utilizing a settlement date for purposes of calculating a lien under 4439. And what that does is if that order gets around without something being put out there by judges like yourself, suddenly gaps are going to start coming around. And suddenly carriers are not going to be protected the way that they're supposed to under that statute. And suddenly it's not paid and to be paid, it's paid, but then depending on when we actually get the money in, when the verdict comes out, when the final judgment comes in, when we actually get around to a motion for equitable distribution hearing, suddenly that's what we're all talking about. And the carrier is going to get absolutely not what they're supposed to get under the statute. And so
Counsel, can you answer the point that was made by Mr. Shepard? Then the vast majority of cases, there's no equitable distribution hearing, and therefore the mechanism or the division that you're making doesn't make sense in those cases.
Well, he's actually right. Just like most cases don't go to trial because people can come to a conclusion of what they believe the reasonable value is between in this case, the full case value, and they agree on the percentage. And in that moment, they go ahead and determine, all right, 11.61%, you got X dollars, my lien is X, I get that because that's how much I've paid. Moving forward, I get 11.61% of my lien. So he's 100% right. This doesn't happen
In other words, there's no gap.
There's no gap. Exactly.
You settle it and you agree to the percentage and you agree the number and there's no gap.
All day. And also you got to think about it this way too, Your Honor. The delta here that caused this 2-year fight, you have to look into this. It was worth the effort. The delta between what they believe the full case value is, which we can't talk about completely because of, there's confidentiality provisions in place. But the delta between the two parties on what they believe the full case value was significant. And in a lot of those cases that resolve between themselves and never get to this point, they're not nearly that big. And so the time value of money and the cost of expense to an appeal comes into play, and people make deals. And that's why 9 out of 10 cases never get to a trial. So the last point I would just like to make is simply that the statute doesn't reference a date. All this talk about the language judgments or settlements as some clear line of demarcation that once a judgment or a settlement is obtained, the carrier ceases to have a lien. Those terms are referencing the mechanism in which a case resolves. They're not referencing a point in time, because think about it a step further. Just because you get your verdict and a final judgment, when does the money actually come in? When does the plaintiff's attorney receive that money to pay it? So, Your Honors, thank you for your time today.
All right. Thank you, counsel. This was well argued. We are adjourned.
Thank you.
Thank you.